Section 4 of the Juvenile Justice Act talks about Constitution of Juvenile Justice Board. It says that in every district the state government shall constitute one or more Juvenile Justice Board for exercising the powers and discharging its functions relating to child or children in conflict with law. And so far as the constitution of board is concerned, there will be 3 members. There will be a principal magistrate who will be a metropolitan magistrate or a judicial magistrate of the first class, and he cannot be the chief metropolitan magistrate or chief judicial magistrate. So besides this principal magistrate, there will be 2 other members who will be social workers, and of whom at least one shall be a woman, and all 3 will constitute a bench so as to conduct the proceedings as per the provisions of the Act. And every such bench shall have the power conferred by the Criminal Procedure Code on a metropolitan magistrate or a judicial magistrate of the first class, as the case may be. And Section 4 Clause 3 says that the 2 members who are to be the social workers, they can be appointed only as a member of the Juvenile Justice Board only when they have been actively involved in health, education or the welfare activities pertaining to children, and they should have been working for at least 7 years. Or such members can be a practicing professional with a degree in child psychology, psychiatry or the sociology or the law. And no person shall be eligible for election as a member of the board if he has got past record of any violation of the human rights of children, or if he has been convicted of an offence having moral turpitude. And such would have been the offence where he should not have been granted pardon or his conviction would not have been reversed. Then he should also not be a person who has been removed or dismissed from the service of the central government or the state government. Besides, such a member should not have indulged in any case of child abuse, and he should not have been engaged regarding the work of employment of child labor. Besides, if he has been charged with any case of human right violation, such a person cannot be the member of the Juvenile Justice Board. It means a person with a very clean record and having a good service, that is a social service behind him, to make him eligible to be a member of the Juvenile Justice Board. And after the appointment of a member as Juvenile Justice Board, within a period of 60 days from the date of appointment, they will be provided training so as to sensitize them regarding the children issues. And the term of the office will be such as may be prescribed under the rules. Then clause 7 of section 4 talks about the termination of grounds for the members of the JJ board. It says that appointment of any member of the board may be terminated only after holding an inquiry by the state government if he has been found guilty of misuse of power which have been provided to him under the Act, or if he fails to attend the proceedings of the JJ board continuously for 3 months, or where he fails to attend less than 3/4 of the sittings of the board. Then he should not have been declared ineligible, as we discussed earlier, that if he is involved in the child abuse cases, in human rights violation cases, or if he has been found engaged with engaging children in child labor, etc., there also he can be removed from his post as a member of the Juvenile Justice Board. Now section 5 provides for the placement of persons who ceases to be a child during the process of inquiry. For example, if a child who is in conflict with law has committed an offence, and during the process of the inquiry he crosses the age of 18 years, because to be a child in conflict with law he must be within the age of 18 years. So where an inquiry has been initiated in respect of any child, and during the course of such inquiry the child completes the age of 18 years, then the inquiry may be continued by the board, and the orders can also be passed in respect of such person if such person had continued to be a child, in spite of the fact that anything contrary is contained in this law or any other law in force. It means if during the period of inquiry, if he ceases to be of the 18 years old, still he will be continue to be treated as a child. Then section 6 says that any person who has completed 18 years of age and is apprehended for committing an offence when he was below the age of 18 years, then such person shall be treated as a child during the process of inquiry. So when the inquiry continues, till then he will be treated as a child. And the person who has been referred to such in section 5, if he is not released on bail by the Juvenile Justice Board, till then he will be placed in a place of safety during the process of inquiry. So long as the inquiry continues, his safety is the concern of the Juvenile Justice Board. They will keep him in a place of safety so that he may not be harmed by the persons who may be interested in. Now section 7 talks about the procedure in relation to the board. So far as the meetings of the board are concerned, they will be held as per the requirement, and in the proceedings, all the proceedings need to be very, very child friendly, and the venue should also be very comfortable. It should not be intimidating to the child and should not resemble like a regular court. It means in a very informal atmosphere the proceedings will be done, or the questioning of the child will be done. And if the board as a bench is not sitting, if all the members are not present, it does not mean that it is not fit for inquiry or for taking up the procedure. There even an individual member of the board can listen the case of the child who is in conflict with law. But where the final disposal of the case is to be made, or the final orders are to be passed, there at least 2 members must be present, and out of these 2 members, one should be the principal magistrate at the time of the final disposal of the case. And so far as the decisions of the Juvenile Justice Board are concerned, the rule of majority will be followed, because there are odd numbers, there are 3 members, so majority rule will follow. But if in case there is any vacancy and the majority rule cannot be applied, there the opinion of the principal magistrate shall prevail. Now let us look into the power, functions and responsibilities of the Juvenile Justice Board. So section 8 says that the board which are constituted in a district relating to procedure of children in conflict with law, they will have certain functions and responsibilities that will include: number 1, they will ensure the informed participation of the child and the parent and the guardian in every step of the process. So not only the child but his guardian or the parents will also be involved in the inquiry process, and their presence will be required. and the board will ensure that the child rights are protected throughout the process of apprehension of the child, inquiry, aftercare and rehabilitation. The board will also ensure that the child is provided with legal aid if he is not able to support, and wherever necessary the board shall provide an interpreter or a translator. For example, if a child is not able to comprehend the language of the authorities who are questioning him or making the inquiry or conducting the proceedings, then an interpreter will be provided if he is not able to understand the language of the proceedings. And the probation officers can be directed along with the child welfare officer and the social worker to undertake a social investigation into the case and submit a social investigation report. So what is the social investigation reported? So whenever a child who is in conflict with law has committed an offence, the study will be made, inquiry will be made into the circumstances to find out what were the reasons, what were the circumstances because of which the alleged crime has been committed by the child. So this is very, very important aspect of the procedure of the Juvenile Justice Board, that an investigation must be done into the circumstances to ascertain the facts about the factor responsible for the commission of offence by the child. And for the purpose of the disposal and adjudication of the case regarding the children in conflict with law, the process of inquiry is specified in section 14 that will be adopted. And at the same time it can be found, suppose the trial is being conducted of a child who is in conflict with law, but the need is felt that he also needs the care and protection. There the order can be made accordingly by the Juvenile Justice Board, and the Child Welfare Committee can also be involved in the process of the case. तो जहाँ पे ऐसे बच्चे हैं जो कि ऑफेंस में इन्वॉल्व रहे हैं, जिनके पेरेंट्स नहीं हैं, जिनके गार्जियन नहीं हैं, और दोज हु आर लिविंग on the roadside or they are involved in the begging or in the child labor, and the need is felt that even where they have been abandoned by their own parents or the guardian. So like last lecture we were discussing that what is the meaning of abandoned child. So it does not mean that the child is abandoned just because the parents have died or one of the parents is missing, or in the families which are afflicted with the divorce, etc., or in the cases of domestic violence, sometimes the children are in the such a position that they are not able to support themselves, and even their family members are not supporting them. So there they may be in need of care and protection. So there, along with the Juvenile Justice Board, the Child Welfare Committees will also be involved in the process. And while disposing of the matter, the rehabilitation plan of the child or the individual care plan of the child can also be provided for, and for this purpose the instructions can be issued to the probation officers or to the district child protection unit. And sometimes the help can also be taken from the non-governmental organizations that are there working for the child welfare. And while conducting the inquiry, it will also be assured that the persons who are being given the care of the child, whether they are fit persons or not. So inquiry has also to be done regarding the person in whose custody the child is going to be placed. So it is the responsibility of the Juvenile Justice Board to conduct the inquiry for declaring the fit persons regarding the care of the children who are in conflict with law. And the members of the board are also responsible to make at least one inspection every month regarding the residential facilities for the children, and to recommend the improvement in the quality of services to the district child protection unit, or to the state government, as the case may be. Then this Juvenile Justice Board can order the police for the registration of the first information report for offences which are committed against any child in conflict with law. So on the one hand, child has himself committed the offence, and on the other hand, someone has also committed offence against him. So he is also afflicted by some kind of offence. There, the responsibility of the J.J. board is that if during the inquiry, during the procedure, if the child is attacked or is human right violation, etc. is taking place, there it is the responsibility of the J.J. board members to register an FIR with regard to that. Then the board can also order the police for the registration of the first information report for the offences which are committed against any person who is in need of care and protection. Because J.J.Act talks about two categories of children: children in conflict with law and children in need of care and protection. So against both the category of children, if the offences are being committed, there the responsibility lies upon the Juvenile Justice Board to lodge an FIR. And then this board will also conduct regular inspections to the jail, which are meant for the adult, in order to assure and in order to check that no child is lodged in such jails. तो जो रेगुलर जेल से उनकी विजिट भी करेगा बोर्ड, ये एश्योर करने के लिए कहीं कोई बच्चा उस एडल्ट जेल में तो नहीं बंद है, उसको तो वहाँ पे नहीं रख दिया गया है. Sometimes because of the scarcity of space, etc., the children are sent to the prison, though that are not meant for the children. And immediately the measures will be taken for the transfer of such child to the observation home. Then other functions can also be entrusted upon as per the requirement. Now section 9 is important, which talks about the procedure which is to be followed by a magistrate, even who is not empowered under this act to take up the cases. Because we have seen that magistrate of the first class or the metropolitan magistrate will be responsible for conducting the inquiry or for taking up the procedure. So if a magistrate is not so empowered under this act, beyond this category, if chief metropolitan magistrate or any other person is taking up the cases, then what will be their procedure? So when section 9 says that when a magistrate is not empowered to exercise the power under this act, but he is of the opinion that the person who has alleged to committed the offence and has been brought before him as a child, then immediately he will record his opinion and will forward the child immediately for proceedings to the Juvenile Justice Board along with his opinion and the records collected. So though he himself is not responsible for conducting the inquiry, but along with his report he will transfer the case to the authorized person and to the J.J. board. And in case a person alleged to have committed an offence claims before a court other than a board that the person is a child or was a child on the date of the commission of the offence, and if the court itself is of the opinion that person was a child on the date of the commission of the offence, there the court shall make an inquiry to determine the age of such person. So if a person has committed an offence, but if he wants to take the advantage that he is not an adult person, he is not a major, but he is a child, there an inquiry will be conducted by the Juvenile Justice Board to determine, and even by the court itself to determine the age of the person. So whether he should be treated as a juvenile within the provisions of this act or not. And its proviso further says that such a claim may be revised before any court, and it shall be recognized at any stage, even after the final disposal of the case. So the question regarding the relevant age of the child in conflict with law may be taken up at any stage of the inquiry or the proceedings, and it has to be settled before the final disposal of the case. And if the court finds that the person has committed an offence and was a child on the date of the commission of an offence, it shall forward the child to the Juvenile Justice Board for passing the appropriate orders. So these are the powers regarding the magistrate who are not authorized to take up the cases under the Juvenile Justice Act. So whenever a case is coming before them, first they will try to find out whether he is a child or not, and along with the opinion he will transfer the case to the Juvenile Justice Board. And if any issue comes regarding the age also, there also the steps will be taken for determining the age of the child. And now section 10, it talks about the procedure which relates to the children in conflict with law. So section 10 talks about the apprehension of the child. So as soon as a child who is alleged to have committed an offence is apprehended by the police, such a child shall be placed under the charge of the Special Juvenile Police Unit. तो आपने देखा होगा थाने में जो है वो अलग से एक स्पेशल जुवेनाइल पुलिस यूनिट होती है, who are responsible to apprehend the children. और वो पुलिस वाली ड्रेस में नहीं होते हैं, वो सादे कपड़ों में होते हैं. और द डेजिग्नेटेड चाइल्ड वेलफेयर पुलिस ऑफिसर who shall produce the child before the board, and without any loss of time but within a period of 24 hours the child will be produced before the Juvenile Justice Board. And the care must be taken that no child has to be placed in the police lockup or in the jail. So the care will be taken to produce him before the board, and if it cannot be done, then he can be taken to any place of safety where he can be kept, and then the proceedings will start. So before within the period of 24 hours he should be produced before the authorities. Now, in order to provide for the persons through whom any child who is alleged to be in conflict with law may be produced before the board, who can be the persons? So not only the juvenile police unit who is there or the child welfare police officer, but also any registered voluntary or non-governmental organizations can also bring the child before the Juvenile Justice Board. So if the proceedings cannot be started immediately, then he may be sent to the place of safety or to the observation home. Now section 11 talks about the role of the person in whose charge the child will be placed who has committed an offence, in whose custody the child should be given, and what will be the role of that person. So any person in whose charge a child in conflict with law is placed must own the responsibility of the child, and such a child can be the child's parent or any other person who is responsible for the child's maintenance. It means so long as the proceedings is continuing or inquiry is being done, the child has to be placed in the custody of someone, and it is the responsibility of the Juvenile Justice Board to see that he or she is a fit person to have the custody of that child. And it further, section 11 further provides that the child shall continue in such person's custody for the period stated by the board, in spite of the fact that said child is claimed by the parent or any other person, except where the board is of the opinion that the parent or any other person are fit to exercise charge over such child. It means sometimes it happens that the parents are themselves involved in some type of commission of crime against their own children. They are themselves perpetrating the violence against child. In that case, the custody or the charge of the person cannot be given to that parent or the guardian. There some other person has to be found fit to whom the custody or the charge of the child can be given. Now section 12 talks about the bail to a person who is apparently a child who is in conflict with law. So when any person who is apparently a child and is alleged to have committed a bailable or a non-bailable offence and is apprehended or detained by the police, or he appears or is brought before the Juvenile Justice Board, then such a child has to be released on bail with or without surety, or has to be placed under the supervision of a probation officer or under the care of any fit person. So if a child has committed a serious offence or a heinous kind of offence, and the offence is bailable or non-bailable in character, there the child can be released on bail with or without surety and can be placed under the supervision of the probation officers or any other person. But proviso says that such a person shall not be released on bail if there appears a reasonable ground for believing that the release is likely to bring that person into association of any known criminal or expose the said person to moral, physical or psychological danger, or the person's release would defeat the ends of justice. तो इन केसेस में जहाँ पे अथॉरिटीज को ऐसे लगता है कि अगर बच्चे को बेल पे छोड़ा जाएगा तो हो सकता है कि उसको कोई नुकसान पहुंचा सकता है या कोई क्रिमिनल उसको ओवर पावर कर सकता है, या there are some dangers of moral, physical or psychological problems may arise, there he will not be released on bail. And such an order of not releasing the child on bail must be a speaking order. That is, it must be supported by the reasons for denying the bail and the circumstances that led to such a decision. Now, if the child is not released on bail, in that case, he will be kept in the observation home. Besides, where a child in conflict with law is not able to fulfill the conditions of bail, if the conditional bail order is issued, then within the 7 days of such bail order, such child shall be produced before the board for the modification of the conditions of the bail. Section 13 provides that as soon as the child is apprehended or brought before the board, etc., the information will be given to the parents, to the guardian, or to the probation officer. Section 14 is important, which talks about the inquiry by a Juvenile Justice Board regarding child in conflict with law. It says that where a child alleged to be in conflict with law is produced before the Juvenile Justice Board, the board shall conduct an inquiry and will pass an order in relation to such a child under section 17 and 18 of this act. So the board will decide what is the age of the child, whether a child is under the age of 16 or he is between the age of 16 to 18 years, and what kind of offense has been committed by that child. Because it has already been told that there are 3 kinds of offenses. There are petty offenses, there are serious offenses, and there are heinous offenses. Up to the period of 3 years, the offenses are termed as petty offenses for the purpose of the Juvenile Justice Act. And where the imprisonment is from 3 years to 7 years, it is a serious offense. But where the imprisonment exceeds a period of 7 years, there it is deemed to be a heinous offense. And if a child has been indicted with the offense of heinous offense, there he may be tried as an adult also, because after the amendment of this act in 2015, now there is a classification of children regarding the nature of offenses committed by them. So different kinds of procedures are to be adopted if a child is under 16 or if the child is up to the age of 18 years but above 16. So there the proceedings are different. So now this inquiry that the child who is in conflict with law has committed the crime, what is the nature of the crime. So all these inquiry will be completed within a period of 4 months. Then this period of 4 months can be extended up to 6 months. So a preliminary assessment will be first made in case of the heinous offences under section 15. And the case will be disposed of by the Juvenile Justice Board within a period of 3 months from the date of the first production of the child. So even if the child has committed a heinous offence, the proceedings are to be expedited, and within 3 months the board must decide the case. So before starting the proceeding, a preliminary inquiry has to be done by the Juvenile Justice Board whether the child has committed a petty offence, serious offence, or a heinous offence. So if the board after the inquiry finds that child has committed the petty offence, and if for the purpose of inquiry the further extension of time is required, then that time will be granted by the Chief Judicial Magistrate or by the Chief Metropolitan Magistrate only. So now certain steps are to be taken by the Juvenile Justice Board, so that whether the preliminary inquiry is being done or the full-fledged inquiry is being conducted, the inquiry must be fair and speedy. So what are the steps should be taken for that purpose? So section 14 says that at the time of initiating the inquiry, the Juvenile Justice Board shall satisfy itself that the child in conflict with law has not been subjected to any ill treatment by the police or any other person, including a lawyer or a probation officers, and will take the corrective steps in case such ill treatment of child has been done. Then it says that all the proceedings which are conducted by the Juvenile Justice Board will be kept very, very simple. In a simplified manner the proceedings will be done, and the proceedings must be conducted in a very child friendly atmosphere, and every child who is produced before the Juvenile Justice Board must be given the opportunity of being heard and that to participate in the inquiry. So when we were discussing the principles of administration regarding the provisions of the Act, we had noticed that principles of natural justice has to be followed during the conduct of the inquiry of the proceedings under the Act. So that thing has to be taken care of. So all the rules of natural justice have to be followed. Then in case of petty offences, the Act provides that it can be disposed of by the Juvenile Justice Board in the manner of summary proceedings as provided under the Criminal Procedure Code. So if the child is indicted with petty offences, there the summary proceedings are to be done. And if serious offence has been committed by the child, then the proceedings will be as if it is done in the cases of summons. And in cases of heinous offences, and where the child is below the 16 years of age on the date of the commission of an offence, shall be disposed of by the Juvenile Justice Board as per the procedure provided for summon case. So where the petty offences are concerned, the summary proceedings will be done, but where the serious and the heinous offences are concerned, it will be taken up as if the summon cases proceedings. And the child who is above the age of 16 years. So up to the age of 16 years the proceedings are different, but if the child is above the age of 16 years on the date of the commission of the offence, then he shall be dealt with the procedure which is provided under section 15. So now what is section 15? So section 15 specifically relates to children who are involved in heinous offences and above the age of 16 years. So that we will take up on the next turn. That what is the procedure for trying the children who are above 16 but under 18 years of age.